Welcome to another episode of Pinsky Law Presents. Today we're going to talk about things you need to know before purchasing your next fire apparatus. Today's lecture is highlighted in Fire Department Law and Management Resource Manual, pages 735 to 739 and page 574. So there are some requirements that are in the law, and there are some that are just good ideas. Bidding is a good idea. I know people think it's a pain, it takes a lot of paperwork, it delays everything, it's too complicated. All those are sort of, but not always true. But bidding will get you the better price, and bidding puts you in charge of a process. If you don't bid, I promise you, the vendor will be in charge of the process, and that's not what you want. Why? You'll see in just a moment. Now, suffice it to say that all villages, fire districts, and city fire departments are required to bid out their vehicles. So what we're about to talk about, they have no option. But the independent departments, those fire departments which are located in a fire protection district and contract at least directly with the town, they're not required to bid their vehicles. But you should. And what I'm finding with our representation of about 500 fire departments and emergency service entities is that these independent departments are just going right to the vendor, having the vendor design the vehicle, buy whatever the vendor says, at whatever the vendor's price may be, and then that's what they get. I'm telling you, and even the state comptroller says it, bidding will result in a better price. Now it's true, bidding can be complicated, but not if you use an attorney who has significant experience in bidding fire vehicles. And just to throw this out there, ambulance services, you also should be bidding your vehicles, and there are enough vendors where you can compete against each other. So what about purchasing from consortiums? Maybe we should just avoid bidding altogether and we should purchase from consortiums. Well, we've had a lot of clients do that over the last couple of years, ever since these became legal. And I got to tell you what we're finding. They're not always cheaper. In fact, the process is actually hurting the fire department. We'll explain why now, but we're going to try to encourage you, just take the time to go through the bidding process and you'll find you'll get better results. So first, we ask, what's the harm at bidding the vehicle? Because you can always go back to the consortium. If you don't get as good a price as you wanted on bidding the vehicle, go back to the consortium, take their price. And you'll always know what their price is even before you bid. And just a note, the bidders also know what the price is before they bid of the consortium. So I think that they try to beat that price. And don't be afraid to prepare bid specifications. An experienced attorney can prepare them for you quickly and reliable. Bid specs only have to be published once in the newspaper, and then you wait 6 days. So you're not really delaying anything except for the time to put into the bid specs. But the 6 days you have to wait to get bids in, not really a big deal. Although, as you're going to see soon, we're going to encourage you to bid and wait 30 days. Now, the big thing with consortiums that I really don't like, they don't allow you to draft the contract. And as you're going to see now, what we want you to put in these contractual provisions are important to you. They give you a lot of protections that you would not otherwise have. And if you use a consortium, you are losing out on important contractual protections. Now look, if you want to use a consortium, you do. There are some benefits for it. We're just saying we think there's a better way to go. So, a couple of warnings. Rule 1, and maybe 2, 3, and 4. Never, never, and never use the vendor's bid packet or bid terms. First, that bid packet, which contains a contract, is not a contract to assist you. Just a kind of point of life experience here. Anyone who hands you a contract is not handing it to you to benefit you. The contract is written to benefit them. The vendor's terms are not in your favor. And I can tell you, there's a lot missing. Never use the name of the vendor in your bid. We see this all the time where we take the vendor's bid packet and our client just sends it out as the bid. And when we read through these, it says, well, you'll have truck vendor, ABC on the back of every seat. And the mud flaps will be truck ABC vendors. And there'll be a big sticker, thank you to truck, ABC vendor. You don't want the vendor's name in your bid. If you do, you're going to face a challenge and you're likely to lose. Why? Because a vendor designed the truck that you're bidding out and then bid on it. That's a substantial advantage, and the Attorney General has given the opinion that that advantage may not be permissible. You can't allow, and you should never allow, regardless of what the law may or may not be, you should never allow a vendor to design a very specific truck that only can be met by them, and then throw the bid out to the public and give someone 6 days to try to compete. Sure, there's certainly an understanding that you want this truck, and there are certain things in that vehicle that maybe only that vendor can provide. That's fine and completely legal, but you need to give everyone a fair chance to see if they can meet the bid specs, or perhaps provide an exception that's comparable. We'll talk about that in a moment. So if you're bidding something complex like a vehicle, we strongly suggest you provide at least 45 days for bidders. Otherwise, they will say that you conspired with the vendor that designed the bid spec and you didn't give them enough time. So 30, 45 days ideally. And this isn't really a big deal because you should be working out your financing in this time anyway. So we want you to have some bid terms that we believe in our experience are so important to protecting you, getting you the best price, and protecting the whole process. These are pretty easy, but let's review a couple of them. First of all, no electronic submissions. Do not allow the vendors to send you an email with their bid packet. Why? Because you can't keep them sealed. You can't tell whether somebody opened them, tampered with them, looked at them. Prohibit these and require sealed envelopes to be delivered to your facility for the bid open. Bid firm dates. This is a big deal. A bid firm date requires a bidder to hold their pricing while the review, selection, and financing process is complete. 90 days minimum, but you'll get 180 days if you say it, and you put that in the bid spec. What you're going to see, they're going to try to say, oh, no, it's only firm for 30 or 45 days. You've got to make a decision now. Well, this sort of arm bending isn't good for your department. It doesn't benefit you. So put in the bid spec 90 to 180 days. I've never had anyone reject bidding based on requiring at least 90 days. Make sure you have a term that says this contract that may be awarded is contingent upon receiving approval of your financing. For example, fire districts, you may have to then go out to the public to get approval to spend that money. That takes 27 to 34 days of notice, and if you're going to bond it, it's another 20 days to publish required documents in the newspaper about your bonding. So you're looking at 60 days anyway. So you need that 90 days above, but also make sure that the bid terms specifically state that your bid's contingent upon voter or bank approval as much as you can. And that way, if the voters vote it down or you can't get good or competitive rates or no bank wants to deal with you, you're not bound to a contract. A bid due date. You've got to place the date that the bids are due many hours or even a day before the bid opening. Don't allow people to walk in at the last minute and hand you a bid. You will get complaints, you will get challenges. At a minimum, what you want is at least 2 to 4 hours in between the time the bids are due and when the bids are open. You don't want anyone sneaking one in there at the last minute. State the bid open date and state in there that no decisions will be made on the bid opening date. You have to let the vendors, the bidders know that you can be there or not, but we're not going to review anything. Don't put yourself under that time pressure. And if you gave yourself 90 days to 180 days of a bid firm date, you're not in a rush anyway. The bid open time. Do not open the bids prior to this time, and always open them in public. Now, I get asked all the time by fire districts, do you need to have a public meeting to open the bids? Well, it is a public meeting, but you don't have to have a quorum of the public to open the bid, or a quorum of the commissioners to open the bid, because you're not going to be making any decisions or having any discussion at that time. So it could just be the secretary or the secretary and the attorney, or just the secretary who's there opening the bids and recording what the bids are specifically. Now the contract. This contract is for your benefit. And I will tell you, for easily over a decade, I've been preparing contracts that benefit the fire department and the fire district way more than it does benefit the vendor or the truck company. And why shouldn't it? You're the one spending $500,000, $600,000, $1 million, $1.2 million on some of these aerials. You should have the protections you need. So, rule number 1, use an experienced attorney who knows how to draft these contracts. That contract should always be attached to the bid. All right, so you're going to have the bid, and the bid's going to specifically refer to the contract and state this contract shall be used for the purchase of the vehicle. And that's one of the bid terms, and we'll write no exceptions. You cannot take an exception to using this contract. If you waited and you didn't attach a contract, they're going to send you theirs. And trust me, you're not going to have the leverage once you've selected the lowest responsible bidder. You're not going to have the leverage to change or put in the terms you want into an agreement. It's too late to negotiate the contract after the bid's been awarded, because then the bidder is truly in control of the negotiations. They already won. They have nothing more to give. And again, as I've said before, no one gives you a contract for your protection, so use your contract. Now, there are some more important bid terms as we kind of get to the end of this. There's a requirement to state that if an exception is being made, identify the exception on the bid and list the substitution made. In other words, you can allow exceptions to be made, but they have to state exactly the substitution. If they're going to give, instead of aluminum, they're going to give steel at a certain part, they should specifically have to say what that is. If you want an Allison transmission versus Detroit diesel, they should have to say what they're going to provide. And also state that the failure to identify an exception and to identify the substitution will be deemed an acceptance of the original bid spec and also grounds to reject the bid. You can copy that, stick it right in your bid. Also state that if an item is bid that is not in compliance with the spec, that it's a breach unless an exception was properly taken. Copy these, put them right in the bid spec, and you can use these exact lines. Now the condition. If you want a new model, you have to state a new model. If you want a certain year, at least a 2020, 2021, you have to say that. You've got to use the year, because what does new mean? We've had issues where somebody has provided a vehicle that was 2 years old, but it was new because it was never used. Bad idea. Always state at least, the chassis shall be at least the year 2021 or whatever that is, or current year, if that makes sense when you're bidding. Late fees. Late fees are your best friend, their worst enemy. You need a late fee. And yes, there are some lawyers who say these aren't enforceable. Trust me, talk to some of our clients. We've got our clients tens of thousands of dollars off the vehicle because of late fees. And the vendor can have any reason they want, any excuse they want for delivering it late. But if there's a late fee, then we don't care about those excuses. So what typical fees do we suggest? Well, if the vehicle's up to $400,000, about $150, $200 a day. And if the vehicle's over $400,000, maybe $250 a day. Now, there's no law on this. This is just what we suggest in our experience. Bankruptcy. I remember when American LaFrance went bankrupt. Great trucks, and all of a sudden, they go out of business. And people had given them a lot of money, and we should talk about that too. But people had given them money up front. They still wanted even in bankruptcy, they still wanted their money. And people were really concerned. Wait a minute, we don't know that you can deliver the truck or repair the truck or get parts for the truck years later. Right in the contract that bankruptcy is a cause for termination. The right to inspect is important. And this is really probably one of the most important things. You need to put down that you have 30 to 60 days to inspect the item after delivery. Now, they will require payment on delivery. We're going to talk about that next. But you should always put, you have 30 to 60 days to inspect the item after delivery. Now, here there's a little give and take. They may say, that's fine, but you can't put it into service. We may be okay with that because you've got to do training for everybody anyway. And during training, when you're running the vehicle through its paces, that's when you're going to find all the things that go wrong with that vehicle. And since in the next slide we're going to hold some money back, 30 to 60 days is what you need. Don't let them say you've got 8 hours to inspect this vehicle. And that's typically what's in a vendor's contract. Now, the date of the payment. Before I get to this one, let me just throw this out. Should you put money up front into the vendor's hands? Sometimes they give you money off. They give you a discount. If they're doing that, and that's a much longer topic we need to get into, you got to be very careful. Let me just give you a peek understanding why you got to be careful. So fire districts, if you bond for the money to buy the vehicle, and you take the bond money and you put it into a bank before the truck is due and before the truck has been ordered, and then you take, let's say, $40,000 and you give it to the vendor then is going to give you a discount perhaps. But the vendor may then start using that money for other things. The problem with this is it's something called arbitrage, where they're trying to make money off of your bond. And this can be a violation of state and even federal law. So before you agree to take a bond payment early and take some of that bond money and give it to the vendor, who then gives you a discount, consult an experienced attorney, because there are important terms that we have to look at and deal with before this happens to prevent both you and the vendor to be accused of what's called arbitrage, basically trying to make money off of borrowed money. And these are public funds, so we can't allow the vendor to try to make money off of the public funds. So, date of payment. I strongly suggest, and I've always gotten away with it, I don't love that term, gotten away with it, but I've always had it stick to a contract without anybody taking it out when it's in my bid packet. The term that says we're going to hold back 10% of payment or more, maybe 15%, until 30 days after delivery, or until my inspection time is up, which could be 30, 60 days. Now, yes, vendors want payment upon delivery, but this is a bad idea. For instance, if you have a vendor who's still owed, let's say, $50,000, $100,000, even $20,000 or $30,000, don't you think they're going to be more receptive to get things fixed quickly, as opposed to if they've had the money in their hands and you don't owe anything anymore, they've been paid in full? So hold back 10% or more in payment. It makes sure that you can get everything fixed. And I've also had the situation where we've taken that 10% after delivery because they don't come back to fix anything, and they violate having delivered a completed vehicle. So if they haven't delivered a completed vehicle because it still needs repairs, in fact, they violated the delivery date, now you have late fees. So you can take some of those as against that 10% holdback. There's a lot of things an experienced attorney can do for you when they write this contract. Now, you know you need more than the delivery date to inspect the item, but this has got to be in the spec and in the contract. Getting near the end now. Warranties. You know, I say you can sneak in a warranty by using the following language. Quote, items shall be delivered without defect and shall remain without defects for 10 years. No exceptions permitted. Think about what that does. That's effectively a warranty. And the contract will also say, written by your experienced attorney, will also say that certain clauses survive the contract even once delivery's been made. This is one of them. Also use, bidder shall repair or replace any defect or non-compliance with the bid terms discovered by owners up to 10 years after delivery. No exceptions permitted. In other words, they're bound for 10 years to replace anything that's broken or didn't comply with the bid. And it will take you a number of years to find some of those things when you open those cabinets or pull that pump panel apart and you're said, wait a minute, this is not what it was supposed to be. It should have been aluminum. It should have been a different shielded cable. It should have been something else. You'll find it later. And with this clause, with these clauses, they'll have to fix it. Disclaimers are important for you. this is a big liability issue. I was lecturing a little while ago in Arizona, and we talked about liability based on vehicle design. This issue came up, and these are the terms you need as disclaimers that, first, the fire department did not design the vehicle and did not supervise the construction, the methods of construction, the materials chosen in the construction or the design of the vehicle. That's very important to protect you against any claims by the manufacturer and by anybody who's injured from that vehicle, whether it's your own members, which is not likely, or members of the public who got hurt. You should state that the fire department is not responsible for designing a safe vehicle, and that responsibility is on the manufacturer. And you should certainly state that the manufacturer must comply with the NFPA and DOT standards in place at the time of construction. All bids should require that the waiver is included, which waives all actions against the owner, and where the bidder agrees to indemnify the owner against any lawsuits or actions of the bidder. In other words, if anyone accuses the fire department and the vendor or bidder of conspiring, then the bidder/vendor should be protecting, defending, paying all the damages and judgments based on what they did, and they should be paying for the fire department's losses. Why? In truth, because vendors run this process. You rely on the vendor, on the truck designer for everything. You listen to them for almost everything. Now, hopefully you've got a good experienced attorney involved, but trust me, these vendors really, they know what they're doing, they know how to talk to you, they design a really good truck, they know the vehicle, and you trust them and you rely on them. But sometimes some of the things they said get you sued. And so you want them to be responsible for the actions or the damages they cause. Finally, 2019, New York State came out with a new warranty law, almost a lemon law, for fire service and ambulance vehicles. All new fire vehicles and all new ambulances sold to a municipality or to a fire company in New York State must provide a full vehicle warranty. The vendor cannot charge you extra for this warranty, so don't let them sneak that in. All vehicle warranties must agree to correct any defects, conditions, and other items which do not conform to a bid specification. That's huge because the bid specs were prepared for your benefit, and now the law requires that they have to fix them. The warranty has to cover a fire vehicle for the first 2,000 hours of service, or for the first 2 years after delivery, whichever is sooner. The warranty period must cover an ambulance for the first 18,000 miles. This is all from General Municipal Law 109-D, and of course you can find a full discussion of the warranty period in this book, the Fire Department Law and Resource Manual. Now, the contract should refer to this warranty regardless, even though it's mandatory. Well, that's it for this episode of Pinsky Law Presents. I hope what you take away from this is get an experienced attorney to assist you with the vehicle purchase and bidding and financing preparations. See you next time on Pinsky Law Presents.